So good morning, everybody. My name is Craig Jacobs. I'm the Director of Business Development for ARGANS Limited, and I'd like to welcome you to our workshop, Building Trust in the Digital Economy. We'd like to thank our partners, the Centre for Commercial Law Studies of Queen Mary University of London, for hosting the workshop, and ESA for funding the project. This workshop is part of our stakeholder engagement, and we look forward to spending the day exchanging views on intellectual property legal protection for Earth observation companies developing products and services in the growing cloud computing environment, and how technologies such as blockchain and smart contracts could support the legal protection to build trust. The objective is to take the learnings from our research, survey, interviews, and this workshop and feed them into our case study development and then test them in the technical implementation of the project. The project will run until March 2021.
Presentation and move on to our first panel discussion of the day, which is the limits and constraints of applicable laws with regards to the EO sector. I am moderating this panel, and I would like to invite our distinguished panelists, Joanne Wheeler, Adina Gillespie, and David Musker, to join us.
Thanks, Michaela.
Thank you, all of you, for being here today. I'm going to very briefly introduce you to our audience. Joanne Wheeler is an alumni of CCLS. She is a leading expert in the field of satellite regulation and commercial contracts. She has worked at Ofcom at the European Space Agency, and for over 20 years, she's been in private legal practice in this area. She was awarded an MBE for services to the UK space industry in 2017. Welcome, Joanne.
Good morning, thank you.
The next distinguished speaker is Adina Gillespie. She is Director and Business Development in GHGSat, which is a Canadian company that focuses on monitoring emissions, especially methane emissions, and monitoring the impact on the environment. She also leads on European institutional engagement and strategic partnerships with the European Space Agency and others. She has nearly 20 years of experience delivering programs and strategic advice in the application of Earth observation technology, including for governments and commercial users. Welcome, Adina.
Thank you, Michaela.
And a third distinguished panelist is our very own David Musker, who is a professor of international design law at CCLS. He has practiced patent and design law for 30 years, and I dare say that he has been at the forefront of shaping this particular area of law in the UK and beyond. Thank you, David, for joining us today.
Pleasure.
We would start the panel discussion by looking at perhaps going from the reflections on the survey and the interviews and the legal complexity when it comes to EO sector. Do you think that the sector as such is indeed so difficult to navigate when it comes to both legal and regulatory landscape? Joanne, can I invite you to speak first?
Thank you, Michaela, and good morning, everybody. It's a real pleasure to be here. there's a quick answer to that is, yes, it is very difficult to navigate, and yes, it is complex. Now, many states have adopted national EO regimes implementing their duty under Article 6 of the Outer Space Treaty to authorise and supervise space activities for their national entities and under their jurisdiction. And the regime often is a balance between the government need for EO data, particularly for national purposes, national security purposes, and the wish to promote commercial EO activities. And there's a well-established commercial capability that all of us are well aware of and growing stronger. But at a national level, their approaches differ hugely. There's no international treaty covering EO and remote sensing, apart from the remote sensing principles back in 86, that are very general obligations. So it's very difficult, actually, particularly for new entrants and SMEs, to really get their head round the legal landscape, and it's very difficult to navigate. For example, in regard to the ability to disseminate data, the ability to access data and ensure access to data, the ability to use data, the ability to own data usage rights, satellite tasking requirements, the ability to create derived products and whether they still have rights over them, and of course intellectual property matters. And some states, of course, characterize data in accordance with the processing applied, and others more in regard to free and restricted data sets. But without this legal interoperability, that I suppose the simplest way of explaining that is similar to technical interoperability, we hinder that growth. We hinder investment, we hinder growth exports, we hinder effective access to it, and we hinder the use of Earth observation for societal and public interest goals. If we had legal interoperability, we could encourage more investment, help monetize EO data, allow national data providers to sell the data more easily and distribute it on a global marketplace. It would actually give us more confidence to put actually certain restrictive measures in place within that framework. We could nurture data processing and data analytic activities, and we would help meet public, sustainable, societal, environmental goals. To give you one example, just a few months ago, for one company, we analysed the regulatory landscape in 27 countries in Europe, but actually a very wide dynamic around the world. Only 8 had a concrete, clear EO policy. 3 kept government databases. All of them had very different measures as to what they classed as national sensitive data, some below 5 meters, some below 1.5 meters. And the coordination, just exactly as you said, Michaela, the coordination alignment of that technology with the licensing terms, the national law and their business models, huge costs actually, and the upshot is the company is still trying to get their head around where to supply data, how to meet societal goals, etc. And it's a real hindrance, particularly for SMEs in the EO industry.
Thank you, Joanne. Thank you for your very comprehensive answer. I would like to ask Adina now, that represents the EO company perspective. Do you agree with this perception? Do you find yourself encumbered by various legal and regulatory restrictions? And how do you deal with that? Do you see any viable solutions, or are you already relying on any? Thank you.
Thank you very much. And I will just concur with absolutely everything Joanne just said. It's bang on, exactly right. The question of legal interoperability is really essential, both on the regulatory side, but on the other legal elements that you've already talked us through today. In terms of whether or not it's difficult to navigate this environment for EO companies, I'll take some liberties because I've been working with a lot of companies for many years. So rather than represent GHGSat itself, I'll speak more broadly on behalf of the community, and I invite any emails contradicting me afterwards, bring in my way. So I would say that yes, it is a really, it's a really challenging landscape to come into. If you're a new entrant, understanding the legal aspects of all of the licensing for each of the different types of data, but not just the data, the platforms that you're using to access the data, and then exactly as Joanne says, the value-added products that come out of it, and sometimes you're not pulling in data, you're pulling in value-added products, and it is really complex. And there are many new entrants that actually just walk away. They have a great idea and it is just way too complicated. And if they tried to pick it apart, the legal fees to do so would just be prohibitively expensive and kill the business in the first place. So there you've got the new entrants coming into the EO sphere, but then there's those of us that have been around for a very, very, very long time. We've been around the loop. We've all looked at different regulations and different legal aspects and copyright and patent this and patent that. But the reality is, most of us don't actually know that much about it. We don't understand the complexities of it. There is just so much. And I defy you to find any Earth observation expert that's not actually a legal person that in fact understands the implications of all of this for their business. And pulling in new technologies and how all that works is a real challenge. But to be honest, you won't very often see people complaining about it. And the reason, in my view, that people aren't complaining about it is that we're not, as a community, generally offering operational services. We tend to focus on R&D programs that lead to the next R&D program, and we do these really great projects that prove the technology, and and they're very impressive. And under R&D projects, you get lighter licensing restrictions. It's easy to run an R&D program, but once you move into operational and commercial services, it's a completely different beast, and we don't very often make that leap. So there are a few exceptions to that, particularly in the defense space and maritime security, different domains like that. But for the most part, EO companies don't have a strong grasp of it. We also don't bring this element into our R&D projects. If you see bids into R&D grant programs, you will not see a section or a work package about what is the legal landscape and how am I going to make this leap to actually operationalize the service that I'm talking about. So there we've got new entrants who just get hit by this overwhelming beast and they're trying to operationalize something. And then you have those of us that have been around a long time, and frankly, it's just so complicated, we don't want to deal with it, and we ignore it. And it's a shame, because it does actually compromise our ability to deliver the services that change the world. And I think there's a lot of potential that could be unlocked in Earth observation if we were to crack this problem. And for that reason, I'm so happy to be on this panel, and I thank you for the invitation. But more so, I'm happy about the work that you're doing and the study that you're doing, and I'm really looking forward to the outcomes and reviewing that when it comes to bear. So there's my comprehensive answer. Thank you very much.
Thank you, Adina, for that. And I'm going to take that and ask David whether from an academic perspective, academic/practical perspective, you see a way of building a more harmonized ecosystem when it comes to intellectual property rights. In my very brief and very high-level presentation, an overview of the available legal mechanisms, we saw that there are a number of EU directives and regulations that do address the core areas when it comes to the majority of intellectual property rights, but it is still a complex landscape. Do you have any idea or suggestion of how we could further simplify this for sectors like this, where companies do not have either the legal expertise or the costs involved in understanding, in decoding this maze of legal restrictions?
Well, thanks, Michaela. I think it's it's interesting to hear the perspectives of Joanne and Adina, and I think also the people you surveyed in the study. And I'm sure that those perspectives are correct. Having said this, stepping outside of Earth observation, this is really just a paradigm case of what big data looks like. This is what it looks like when you take vast amounts of data, glue it together from several sources, and try and put the result to practical use. This is what you get. So we're not dealing here with a situation that is unique in nature, although some of the features of Earth observation, like the very high public goods involved, the high levels of public investment involved, and therefore the stronger public-private partnership elements, those are perhaps particularly marked in this sector. So there are answers from elsewhere in the technological space, and you know, in technology we've solved similar problems in terms of putting together global mobile communications in collaboration between EECS, let's say, and the private mobile communications companies. We've put together programs that allocated spectrum for satellite mobile communications. That happened when everybody thought it couldn't happen. So these things are solvable. I think the key from an IP point of view is to step away from looking at the rights, because your talk quite correctly explained that even within Europe they're a bit messy, and as soon as you put the world perspective on it, the European database right, which you mentioned, which is probably the most relevant right in this context, doesn't exist anywhere else. And in fact, the very existence of the European database right has been used in, for example, Australia in the Telstra case as a way of saying, well, we don't have one of those, and therefore databases clearly aren't protected in our law. So we don't have a harmonized international position on protection. The better solution is to look to licensing and contractual terms. Now, there's fantastic potential in the copyleft model, in open source models. These models work by putting downstream constraints on everyone downstream in the process that they themselves will use the results in a certain way. So having a harmonized and standardized set of license terms is where you want to go. There are experts in blockchain on this meeting and speaking later, and blockchain may well be a fantastic way of capturing the diverse contract terms attaching to different pieces in this. That might be one of the solutions to the problem, but having those contract terms in place is the key. Just pulling back a little bit though, contracts work when they work, but as you say, they're between parties, they're not against the world in general. To make free and open source licensing copyleft models work, you have to have some protection in the first place. Because if you haven't got any protection, you've got nothing to license. And if you haven't got a license, you haven't got the enforcement if somebody breaks the terms. So we do need some basic level of global underpinning of IP. This is paradoxical, but you need the protection if you are going to make the data available freely. Without that, you don't have any means of enforcing free use of the data downstream. So I would say some basic level of globalization, a global agreement on protection of data is required here. And then beyond that, public-private discussions to devise for this industry licensing terms that work in terms of giving the public back what it needs to achieve public goods and giving the innovators back what they need to get some flow back of their investment.
Thank you, David. Again, a very comprehensive answer to the issue of the lack of harmonization and whether this relates to national-based legal principles or whether it relates to different technology, different platforms use different parties involved and different types of users. My last question, which is open to all of you, is given this complexity, this maze of legal and regulatory restrictions attached to EO data from the very beginning, and they kind of snowball as the data travels through the value chain, who do you think is best placed to drive harmonization in the sector, to introduce more standardization when it comes to, for example, the license agreements? What do you think, as a sort of hopeful message to all stakeholders in the sector sort of going forward?
Maybe I could jump in on that one to kick it off, if you don't mind, everybody. That's a great question and a really difficult one to answer, but I think the key is that it needs to be inclusive. So coming up with standardization is essential, but as a data provider, I also have commercial objectives that I'm trying to meet, and I need to meet those. So if there's a standard way of doing this that I can buy into and still meet my commercial objectives, then this is a great thing. And we need an entity that can appreciate that can appreciate the public sector investments and align those types of licensing agreements, but also the private sector who is increasingly playing in this. Now the organization that comes to my mind is the OGC, the Open Geospatial Consortium, because they have this ability to put together standards that bring in those different entities. I don't know that it should be them, but whoever does it needs to include all of those perspectives, because if the commercial perspectives are not included, it will simply not work, because the small innovative companies, they'll just go and do their own thing. It will exist independently and you won't have that harmonization. And as a small company doing exactly this, I'm very happy to buy into a global or a regional standardized approach if it's in line with my commercial objectives. And I think that's the key from my point of view, for sure. Thank you.
Thank you.
Michaela, may I jump in? So it's my turn to agree wholeheartedly with Adina, but we need to recognize that all Earth observation data is not the same. So we need to balance very carefully the public objectives and the governmental objectives, the institutional objectives with the commercial activities, and almost divide Earth observation remote sensing data up into what is the public good to maximize societal benefits. And that is a different dissemination model compared to actually offering a return on investment to private commercial companies. We need to identify where dissemination is vital for disaster management, immediate access, etc. And there can be some flexibility. We saw with the US waived its 24-hour access to remote sensing data in regard to the Indian Ocean tsunami in 2014. Any standardization must be inclusive. It's really, really important to engage, particularly with the small companies coming up that are very innovative. And then we have to look at the tools, I call them, that institutions and governments have, the statutory, regulatory policy and enabling tools, and look at how they work. I think there will be some standardization and harmonization because of the competitive landscape, and because I see that some best practices will slowly develop. And then I also agree with David and Adina that we then need to look at how this works for commercial companies, licensees, waivers, contracts, terms and conditions, reuse, sub-licensing, and I have to and try and keep these agreements as uncomplex and standard, with standard definitions as possible, because I'm actually seeing these contracts getting more and more complex, and my role is to pull them back and keep them simple and standard as much as possible. But it's a fascinating subject that is incredibly pertinent right just now.
Thank you.
Sorry, Michaela, I was just going to jump in. I mean, I can't name the person who should do this. It's good to see in recent years the Commission stepping back a little bit and saying to the sector, come up with your own industry practices. There's a lot to be said for that. At the same time, in IP in general, we do sometimes see, if you leave it entirely up to the private sector, you wind up with patent pooling, which works very well for the current incumbents and works against new entrants. So there has to be, I think in this sector particularly, there has to be a public sector involvement, not only to look after the public sector's interests as a generator of data and a consumer, but also to keep the ring open for new entrants.
Thank you, David. We have 2 minutes left before the end of panel discussion. So unless you have any particular comments or any further suggestions that you would like to add, I'm going to quickly wrap up and pass it on to the next panel discussion.
I'd just like to say thank you. It's unusual to find a group of people that's equally interested in this topic. So thank you very much for the invitation and organizing this panel.
Thank you. And also that everybody agrees.
Yeah, I want to reiterate the thanks too, but also to say how pertinent this is. The UK, as Adina well knows, are now looking to have an EO data regulatory policy. So let's see how that looks compared to the rest of the landscape. Thank you.
Great.
Thanks to fellow panelists. It's been a really interesting session, though brief, and I'm looking forward to the rest of the day.
Thank you all for joining today and for sharing your expertise.